Now, foreign national lawyers as well as students have been dealt a major blow following a constitutional court ruling. The court has found that only South Africans or permanent residents should be admitted as lawyers. It's affirmed a section of the Legal Practice Act that states as much. What does this mean for foreign law graduates who have completed their studies in South Africa? Well, Academic Director of the Pabasa Pius Langa School of Advocacy, that's Sha'ista Kazee, speaks to us now to just get further clarity on this matter. Sha'ista, good morning and thank you very much for your time. Firstly, your reaction to that unanimous decision finding that the section of the Legal Practice Act that only allows South Africans or permanent residents to be admitted as lawyer is in fact constitutional.
Ms. Bombalane, thank you so much for having me on your show. I think it's such an important issue to enter into our public debate. It is an incredibly disappointing judgment for two reasons. The first is for law graduates holding South African LLB degrees, and secondly, for that the judgment doesn't truly align with our international and regional obligations of solidarity and integration in the SADC region. More particularly for the individual graduates and law students, they are now, it's confirmed by the court that they are now unable to come before the Legal Practice Council and get admitted as a practitioner. So while this does not mean they cannot use their LLBs in other professional areas, they certainly cannot practice before the high courts and our superior courts as an admitted professional and give legal advice to individuals. And I think for many graduates, this is a heartbreaking end to what is often a 4 or 5 year degree. And that's really the troubling aspect of the judgment.
Mm-hmm. I read there the Justice Ministry's submissions. They were of the view that in this instance, law is not a rare or scarce skill. So for them, the Justice Minister felt they could not make available a new dispensation to cater for these particular individuals. What did you make of that?
Thank you. The primary issue or difficulty that Pabasa, the Pan-African Bar Association, had with that submission is that the Justice Ministry was truly conflating two issues that are separate. The first is the immigration status of individuals, which has always been the designation and purview of the Department of Home Affairs, and we accept that entirely, as opposed to the question of who may practice in a particular profession. And in this case, and certainly in respect of all the applicants that were before the Constitutional Court in this matter, they had all had their immigration status confirmed in various means. It might be a spousal visa, it might be a work permit, it might be all sorts of appropriate intercompany transfer permit. Immigration processes must happen properly and efficiently and correctly. But this question that the bar placed before the court was an issue of, is there an exclusivity in one particular profession? And so with respect, our view was that the Justice Ministry was incorrect in trying to merge the argument with one of immigration, special skills, and matters and bureaucracy that is appropriately within Home Affairs.
Mm-hmm. But now it has been upheld because essentially what has been stated is that if you do not have the permanent residency or you are not a citizen, it still remains. But it really sort of poses a bigger challenge because just reading through the judgment and going through some of the facts of the cases for each of the individuals, like you said, they were holders of some form of a permit, be it the ZEP for some of those graduates, the others it was spousal visas that they were here on, but somehow they came to a point where there would be a problem to convert these because of the law currently, for instance, governing the ZEP, that you cannot at any point, if you are in South Africa with the ZEP, you cannot say because you've been here for 10 years, then that can be converted and allow you to get the permanent residence. So it is a challenge, but one doesn't know how then do you resolve it if you're in the country and studying towards a law degree and want to be admitted.
Mfundo, you have hit the nail on the head. You've identified exactly where the what Pabasa contended was the violation of the rights to equality and dignity lies. This is not an issue concerning any kind of illegal or uncertain migration status individuals. These are people that have chosen to make their life here. And I think the public is well aware of the difficulties with the Department of Home Affairs in processing and dealing with permit applications of various kinds. And so it really is about the individual graduates and applicants. Much has been said, I've noted over the past 3 days, about their ability to work in-house as legal advisors, as consultants, etc. But really the harm is not the ability to work. The harm is to work in a vocation of your choice and where you have always wanted to practice. I think one important factor, Mfundo, I don't want to speak too long, but is to recognize that all of the people concerned have LLBs from South Africa, have law degrees from South Africa. This is not a case of people who are qualified elsewhere and need to understand or appreciate the South African legal system. That is simply not the case. I think one of the things that the judgment did not touch on, but I think is very important, is that there does appear to be a trend of viewing migration as a security risk. And I think that is, and this level and development of migration rhetoric is quite dangerous. And it is completely against and the way in which law specifically is practiced. In an increasingly globalized world, there's cross-border commercial transactions, there's cross-border litigation. It is of utmost importance that our legal profession remains a profession that is connected to the rest of the world, that can never be isolated on legal theory or in practice. And so it is so important to have the broadest variety and of participants who agree to uphold the South African Constitution and the rule of law. And so I know I've embarked on a bit of a consequence, but it is an important aspect.
But it seems, though, unfortunately, that it seemed that all the justices were persuaded by the Justice Ministry, because, I mean, they went on to even state that foreign nationals who chose to study in South Africa would have made the choice conversant with the fact that they are not eligible for admission. So they're saying, as a start, they assumed that they would be aware that they would not be eligible at any point in their lives. So clearly quite persuaded, and it was a unanimous decision.
Absolutely, that is absolutely correct. And, the LPC is a new piece of legislation. It's about 4 years old now. And the one thing that we can take heart from that unanimous court decision is that the court absolutely rejected the idea that practitioners, which was also advanced, might I add, by the ministry or the Minister of Justice, that these individuals would not be able to uphold or adhere to the Constitution and the rule of law. I think it is promising that even in accepting aspects of the Minister of Justice's argument, the court was vehement that one cannot presuppose an allegiance to a system of law or rule of law merely based on one's nationality.
Yeah, correct.
And I think we need to take heart in that.
No, it's certainly something worth noting. Sha'ista, thank you very much for talking to us. That was Advocate Sha'ista Kazee, Academic Director at the Pius Langa School of Advocacy.